Quickies, please. One common feature of all totalitarian systems is known as papers, please, where a cop or someone in authority can stop someone at any time and demand to see their identification. If they don't have it, they can arrest them or, in extreme cases, execute them on the spot. The United States has never been such a country, although cops want you to think it is. The definitive case on this is Hiibel v. Humboldt City, Nevada. A deputy had stopped Larry Dudley Hiibel, who was parked on the side of the road with his daughter, who was driving, and asked for his ID. Hiibel said he didn't have any reason to tell him and asked what he was being accused of. The deputy just said he was conducting an investigation. The deputy arrested Hiibel and charged him with willfully resisting, delaying, or obstructing a public officer in discharging or attempting to discharge any legal duty of his office. Hiibel was convicted, and his appeals to the District Court and Nevada Supreme Court failed, so he took it to the Supreme Court. In 2004, the Supreme Court ruled that a cop could require someone to give their name during a valid Terry stop without violating the Fourth Amendment, if the state has a statute requiring it. Note that this was only about a detainee giving his name, not requiring a show of identification. It's the same kind of Supreme Court slippery slope we've seen. If a Terry pat is reasonable and asking the name is less invasive, then it must be reasonable too. But the Terry pat was reasonable for reasons of officer safety. Knowing his name had nothing to do with that. In his dissent, Justice Stevens wrote, "In my judgment, the broad constitutional right to remain silent, which derives from the Fifth Amendment's guarantee, is not as circumscribed as the court suggests and does not admit even of the narrow exception defined by the Nevada statute." He said it makes no sense that an ordinary citizen should have less rights than someone who's a target of a grand jury. Breyer, joined by Souter and Ginsburg, made an even stronger dissent. There is no good reason now to reject this generation-old statement of the law. There are sound reasons rooted in Fifth Amendment considerations for adhering to this Fourth Amendment legal condition circumscribing police authority to stop an individual against his will. With certain exceptions, such as traffic stops where a driver can be required to show a license, police can only demand your identity if your state has stop and identify laws and there is reasonable suspicion for the detention. 25 states have stop and identify laws. It's good to check and see if yours does.